I'd like to call this meeting to order. Welcome back after the break week, everyone. Welcome to meeting number 35, the House of Commons Standing Committee on Justice and Human Rights, pursuant to order, Standing Order 108, Sub 2, and the motion adopted on September 22nd. The committee is meeting to begin its study on the subject of Bill C-28, an act to amend the Criminal Code, self-induced extreme intoxication. Today's meeting is taking place in a hybrid format, pursuant to a House Order of June 23rd, 2022. Members are attending in person in the room and are remotely using the Zoom application. I'd like to take a few moments for the benefit of the witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you're not speaking. Interpretation for those on Zoom, you have the choice at the bottom of your screen of either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed through the chair. For members in the room, if you wish to speak, please raise your hand. And for members on Zoom, please use the raised hand function, and the clerk and I will manage the speaking order as best we can. We appreciate your patience and understanding. Yes.
Merci, Monsieur le Président. Merci de m'accueillir à votre comité ce matin.
Thank you very much, Chair. I would like to, as customary, ensure that tests for interpretation have been done before we begin.
Yes, they have, and thank you for asking, and I think they've been done, so all are good so far. I do have cue cards as well, so when you have 30 seconds remaining, I'll raise the yellow cue card, and when your time's up, I'll raise the red. So I don't like interrupting, so if I can avoid that, that's my easiest cue card, so try to watch for that. And just for Mr. Perrin, our tests have been done. So now I'd like to welcome our first hour witnesses. Appearing today, we will have Benjamin Roebuck, Ombudsman to the Victims of Crime. It says here video conference, but I believe you're right here. And then we have Rhiannon Thomas from Women in Harm Reduction International Network via video conference. So we'll begin with you, Mr. Roebuck, for 5 minutes.
Thank you. Honorable Chairperson and members of the committee, thank you for the invitation today. It's very nice to meet you all. Today we're here on the traditional unceded, unsurrendered territory of the Algonquin Anishinaabe people. I acknowledge our shared responsibility and my personal responsibility to work to address historical and ongoing colonialism, racism, and oppression of Indigenous peoples. This includes working together to dismantle the criminalization of Indigenous peoples and learn from the resilience and vibrancy of diverse Indigenous cultures. As you may know, I've been recently appointed. I'm so thankful for this opportunity to serve victims and survivors of crime in Canada, and I'm brand new 3 weeks in, so please be patient as I get caught up to speed. I'd like to thank the members of this committee for the tireless work on justice and human rights that you do. I know there have been many recent decisions by the Supreme Court of Canada, as well as government and private members' bills that require your attention. The Office of the Federal Ombudsperson for Victims of Crime is an independent resource for victims in Canada. Our office was created to help the federal government honor its commitments to victims of crime. Victims contact our office to learn about rights under federal laws, to learn more about federal services available to them, or to make complaints about any federal agencies or federal legislation dealing with victims. We help to problem solve and find solutions when victims' rights have not been respected, and we collaborate with stakeholders across the country to identify emerging trends or issues that affect victims of crime. Based on this work, when appropriate, we offer recommendations to federal agencies and help to ensure that victims' concerns are considered in the legislative process. When the Supreme Court of Canada ruled in R.V. Brown that Section 33.1 of the Criminal Code was unconstitutional, it had immediate and adverse effects on survivors of violent crime. The wording of the law and the language used by the SCC are difficult to understand and contributed to widespread misinformation about highly traumatic and personal experiences in the lives of Canadians. Organizations supporting women who have experienced gender-based violence and many young survivors of sexual assault in particular believed that the government had allowed space for intoxication to become an allowable defense for violence imposed on the bodies of women and girls. This belief caused considerable distress, resurfacing of traumatic memories, and protests in high schools, where young survivors shared personal experiences, sometimes without the resources to do that safely. As ombudsperson for victims of crime, I believe there was an urgent need to act, and I'm thankful for the way the whole government moved quickly to respond to the SCC ruling. I also appreciate the clear messaging from the Minister of Justice and Attorney General of Canada, the Honourable David Lametti, when he said repeatedly, being drunk or high is not a defense for committing criminal acts like sexual assault. I think this showed empathy and that it reflects a hopeful posture to act on other concerns raised by victims of crime. I also understand that the unconventional approach to passing this legislation before it could be fully considered and weighed in our parliamentary committees has created an obligation to meaningfully engage in that process now. The full continuum of intoxication caused by alcohol and other substances is a very present reality in many of the contexts that lead to criminal victimization. In the messy realities of these situations, people can slip in and out of their awareness of their behavior and their impact on others, making it difficult to establish objective criteria about culpability. Other witnesses will explain that the defense of extreme intoxication is predominantly advanced by men perpetrating violence against women. And as the Government of Canada launches its national plan to end gender-based violence, I urge you to consider this legislation through that lens. Our office has a few simple recommendations, 3 that I'll leave you with. Number 1, clear language. Continued misinformation about this legislation will have consequences on women and girls. The wording of C-28 is complicated, and we recommend continued and clear messaging to the public. Number 2, meaningful consultation. The diverse perspectives of Canadians emerging in the committee need to shape the legislation. We recommend that making revisions to the legislation if significant concerns are identified through committee. And 3, monitoring. Intoxication is very common in contexts of violent crime. And you've heard significant concerns from women's groups and survivors about the possibility of this defense being abused. We recommend a formal review after 2 years to evaluate how the defense has been used in court. Thank you again for your time. I look forward to the conversation.
Thank you. You were right on time, Mr. Robeck, and welcome to your new role and to appearing for the first time on this committee. Next, we have Ms. Thomas for 5 minutes.
Thank you. Thank you to the committee for your invitation to have Women in Harm Reduction International Network, or WRIN for short, speak about Bill C-28. My name, as you know, is Rhiannon Thomas, and I'm here as the rep to speak about considerations similar to the previous speaker. So just as an introduction and for context, WRIN was formed in 2009 as a response to a worldwide scarcity of services, research, training programs that are inclusive of women, female identified and gender diverse people who use drugs by the global community of women who use drugs, drug policy, and human rights activists. WRIN has spent the past 15 years working to improve the availability, the quality, relevance, and accessibility of health, social, and legal services for women who use drugs. WRIN reminds the committee that drugs, including alcohol, while sometimes associated with violence, cannot be seen as the direct cause of violence. WRIN would argue that drug dependency is not a disease or an illness, nor does drug use per se negate free will or intention. I'm certain that the honorable ministers on this committee will be very aware that women are most often the victims of violence, physical, sexual, socioeconomic, and by that I mean that women in relationships where gender-based violence occurs often do not have the economic means to freely or safely exit them. Children, as the committee knows, are often also caught up in these situations as well. And as the previous speaker has said, it is most likely that men who engage in intimate partner and gender-based violence will be attempting to use this defense if it is made available to them. For some men, both drug use and intimate partner violence may be expressions of a need for power and control related to gender-based insecurities. Intimate partner violence is usually inflicted by men who, buoyed up by patriarchal context, believe that violence is opposite in certain situations. Such violence occurs in settings where the perpetrator is in control and must be understood as deliberate and, at some level, premeditated, independent of the amount of alcohol or other drugs consumed, if any. Incidentally, this insight has implications for services designed for violent perpetrators, where drug use should evidently be considered as a secondary factor in violence prevention interventions, given that the intention to inflict violence invariably precedes alcohol or other drug use. Sexual violence is a place where we must be particularly careful in the use of this defense. Women are overwhelmingly the victims of sexual violence, and this type of crime is one of the most underreported due to the burden of not having police believe narrative evidence. And even when cases get to court, survivors are cross-examined without trauma-informed approaches. If a survivor is a noted person who uses drugs, for example, their memories of the events are often discredited. In this way, a survivor can be blamed for a sexual assault while the perpetrator, using this defense, has the potential to be acquitted for being intoxicated. Additionally, if we consider gendered socioeconomic realities, women also have less access to legal supports. In most provinces, legal aid supports have been slashed for many years so that they are accessible only for the accused who are facing jail time and not for survivors. Further, as parents, and often as the primary caregivers, women who may want to invoke such a defense may be reluctant to do so due to the threat of losing child custody. Importantly, also, due to the criminalization of many commonly used drugs, research on their physiological effects is limited, which would also impact the limitations of the use of this defense. To properly study if and how many drugs affect perceptions and ability to make informed decisions is difficult, if not impossible, given the exemptions required. One drug we do know a lot about is alcohol, since it's legal, and we do know that it affects inhibitions, perceptions, judgments, and so on, and has been clearly linked with violence, perhaps not causally, but with violence in many studies. Finally, the criminalization of drugs, drug use, and people who use drugs must also be considered. How will this affect communities that are most impacted by prohibition? Black, Indigenous, and poor people in this country who are most often disproportionately incarcerated and have less access to pricey lawyers, and certainly are not going to be in a position to pay for expert witnesses who can make assertions about the levels of intoxication and their relation to criminal intent. Again, I also would refer to the rising numbers of women, particularly Indigenous women, in the federal prison system. You can easily find these numbers on the Canadian government website, and I would encourage the honourable members of this committee to also read the report from the Office of the Correctional Investigator that was released last week that pointed to how those numbers are increasing and how Indigenous prisoners, especially female prisoners, are in prison longer, in maximum security more often. And I ask, will this defense be accessible to these Canadians?
Thank you, Ms. Thomas.
In summary, I'm sorry, I had one more thing to say. Do I have time? Okay. In summary, RIN's position here around this issue is that we see no evidence of direct causal association between drug use and violence or other offenses. However, it is clear that mitigating factors should always be considered holistically without drug use per se alone being an isolated factor. Contextual issues, acting under duress, threats, intimidation, exploitation, gender, history as violence, all these things should be considered together, and mandatory simplistic views should always be avoided. Thank you.
Thank you, Ms. Thomas, and welcome to the committee. I'll now go to our first round of questions, beginning with Mr. Brock for 6 minutes.
Thank you, Mr. Chair, and good morning, Ms. Thomas and Mr. Roebuck. Thank you so much for your appearance today to help us in this important study. So I'm going to try to balance my questions with respect to both witnesses. It really depends on the timing. I know I only have 6 minutes. But firstly, to you, Mr. Roebuck, I want to personally congratulate you on your appointment to this particular role. It is a role that is so vastly important to victims in this country of ours from coast to coast to coast. And I would be remiss if I did not highlight the fact that this particular position was left vacant for close to 13 months, notwithstanding the cries from the official opposition and other members of the House of Commons to fill this, because there was a need for victims to be heard. As you have indicated in previous testimony, I've done a little bit of research, there is a real disconnect in terms of the equality in the criminal justice system between the rights of the accused and the rights of the victims. You specifically have opined, specifically with respect to the Charter, Section 15 of the Charter and Section 28 of the Charter, and how there is that particular imbalance. So it's so important to have you here filling this particular role. It would have been so helpful to have your knowledge, your background when we studied Bill C-5, and also when we studied just most recently the victims' rights with respect to participating in the criminal justice system. So that being said, I do want to have you give you an opportunity to perhaps expand upon some of the recommendations that you spoke about, because as a former Crown attorney, I'm just so acutely aware of the abysmal statistics that we have in terms of successful prosecutions in this country. It stems from lack of reporting. It stems from a lack of knowledge of rights. It stems from a lack of trust that victims have with police authorities, with participants in the criminal justice system. You yourself have opined that there is a great deal of misinformation that was largely alarmist as the moment the Supreme Court of Canada released the decision. So I'd like to hear from you, sir, as to what particular steps your office is taking to perhaps assuage some of these fears and some of the concerns that victims have, particularly as it relates to the Supreme Court of Canada decision and the government's response with the passing of Bill C-28.
Thank you for the question, Mr. Chair. I'm here and ready to work, and we're starting by engaging stakeholders and listening. I don't want to come in with a pre-established agenda, even though there's clear issues that need to be tackled. I think we need to hear directly from victims and survivors of crime across the country, but what are the pressing issues right now that need to be moved on? I think one of my keen observations at the moment around legislative changes that are happening is that I don't think that it's right to dismantle mandatory minimum penalties without considering increasing protections and access to justice for victims of crime. So there has to be some compensation in that equation, which is why I'm very interested in Bill C-233 about the potential use of electronic monitoring as a way of protecting women's safety if offenders are given the option of conditional sentencing. So I think we have to look at the balance when we're making decisions as important as that.
Okay, so specifically I had asked, sir, what your office is doing to contribute to the overall knowledge component as part of your recommendations moving forward. You mentioned knowledge, greater consultation, making revisions to the legislation, and monitoring the data. So those are the four highlights that I heard from your presentation. I've heard from other witnesses that it was important for the government to respond appropriately to the Supreme Court of Canada decision. I am not critiquing the government. It was appropriate they do that. We urged them to do that. But there has been a great deal of criticism in terms of the speed by which they passed the legislation without proper consultation and without proper public announcements to victims groups so that the public can be informed that this is not going to be opening up the floodgates for future litigation. As I indicated at the outset, it's bad enough to convince a victim to participate in this process. I personally engaged in a number of roundtable discussions, and notwithstanding my highlights of Bill C-28, there is still that fear out there that the defense now has another tool available to them to litigate. So I'd like to know what your office is doing to assuage those fears.
We will work, we have an advisory committee that we're ready to re-engage of service providers across the country who are keenly interested in this issue. A number of women's organizations and groups that are very interested in monitoring this outcome. So we'll look to stay on top of how it's being used in the courts, that our office will monitor that as well. And we hope to come back to committee with an evaluation of how it's being used. I think it's really important to understand that the perceptions of legislation are what people act on. So in abusive relationships where there's coercive and controlling behavior, any misperceptions around the way that this can be used, you can have an abuser trying to convince a victim that it can't be reported because they were intoxicated. So I think the clarity is really important, and we'll try to promote clear messaging on this to the best of our ability.
Thank you, Mr. Brock. The next round of questioning goes to Mr. Nakvi for 6 minutes.
Mr. Chair, and I also want to start by congratulating Mr. Roebuck on his appointment. 3 weeks in, I'm sure you're learning something new every day. I'm sure that will continue. I'll start my questioning with Ms. Thomas. Thank you for joining us today. Can you share with us, in your organization's experience, what was the reaction of the communities that you work with when the Brown decision was rendered by the Supreme Court of Canada?
Thank you for your question. In our organization, the immediate reaction is that the concern from the community that this kind of defense is going to do more damage to people who are victims of violence, because already the balance is so not in favor of victims of violence. So, yeah, I don't really know what else to say. There is a real concern about providing perpetrators of violence with more power in the court system.
So do I read correctly from your response that you had hoped, as you saw that government act or the parliament acts as fast as possible in making it absolutely clear that such a defense does not exist?
I think, yes, if that is the reality. I think from the perspective of our organization as well, what ends up happening in the courts will really be the evidence that we would use to analyze what's happening. Well, I agree that it's important that the government, is clear about what the laws mean and how that works out. But ultimately, if the courts rule in favor of someone who is violent, especially depending on the substance that they are using, and using that as an excuse for violence that is premeditated or a separate issue, that will continue to be a concern.
What are your suggestions in terms of making it even more absolutely clear that intoxication or just being high is not a defense, is never a defense when it comes to perpetuating any crime, in particular as it relates to sexual violence?
I'm sorry, can you repeat the question?
I'm asking, in your view, what else can be done or the government could do in making the point absolutely clear, as has been in this instance. The Minister of Justice and other government officials were very quick to highlight that just intoxication or being high is not a defense towards committing any crime or sexual violence. Clearly, I'm of the view we have more work to do in that regards to to educate people, men in particular, that it's never a defense. What is your recommendation in that regards as to what else can be done?
That's a great question. I would say that real investment in support services for women and families who experience intimate partner violence and gender-based violence would be a crucial step because those services are rare. The shelter system, for example, for women who are escaping violence is very full at all the time. And this was particularly highlighted during lockdowns and the pandemic. So I think really looking at investment in services that are there for women who are victims of violence, and particularly sexual violence. I can't overstate how overwhelming it is to try to report sexual violence to the police. I'm sure all the honorable members of this committee will understand the dark figure of crime when it comes to sexual violence, that it is very, very difficult to report that. And then even once you do, going to court is a very traumatic system, excuse me, because there are not supports there to help people get through that system and get through that process.
Thank you. Mr. Roebuck, I've got probably about a minute and a half left. Your last recommendation was around data collection. Can you expand on that? What kind of data set you're speaking of? How do you suggest that data be collected? And most importantly, how can it be used to protect victims of sexual violence?
Thank you for the question. Mr. Chair, I believe that an appropriate way of collecting the data would be to look at every instance of the defense being used in court and look at success factors, and when it's unsuccessfully used, look at the nature of the cases where it's being used to evaluate if it is disproportionately affecting violence against women like we've seen in the past. I'm not sure yet of the proper mechanism within government to do that, but certainly our office will also keep an eye on its use and likely commission a study in year 2 to report back on the work.
And do we know if that data is being collected at the moment? Do you have any sense, even from an academic circles, given your background?
Yeah, there's an excellent research center at Western University where some of that data is being monitored. Thank you, Mr. Chair.
Thank you, Mr. Nakvi. Next, we'll go to Monsieur Perra. Welcome to the committee.
Thank you very much, Chair. Thank you to the witnesses for being here. Starting with Mr. Roebuck, thank you. Congratulations for being appointed to your position. Unfortunately, the position was free for quite a while, as was mentioned by my conservative colleague. In your presentation, you made recommendations fairly clear. You want clear language, and you want to have consultations that are meaningful and recommendation, but I sense from this that you have some fears regarding this. And do you think that in this bill we have found a balance between the rights of victims and the rights of the accused, or do you think there's more that needs to be done?
That's a great question. Mr. Chair, in general, in Canada, we have work to do to balance the system with regards to the rights of offenders and the rights of victims, where the rights of offenders are guaranteed under the Charter, and victims typically have to ask for their rights to be respected, and there's no recourse for them to follow up outside of a complaints mechanism, which is part of why our office is vitally important to victims and survivors of crime. I think in terms of clear language, it's not accessible to the average Canadian to understand. I just want to read this portion of the bill. They departed markedly from the standard of care expected of a reasonable person in the circumstances with respect to the consumption of intoxicating substances. For a survivor of sexual assault who tries to look and understand the law, that's not clear. And so the messaging has to be there because already, as Ms. Thomas has pointed out, we know that less than 6% of sexual assaults in Canada are reported to the police. So if women feel that they're not going to be believed because there was intoxication involved, that's significant. We need to clarify that. And we need to look at this issue also in the context of drug and alcohol policies and harm reduction, and consider the importance of safer consumption programs as a means of people using more safely than in other contexts where private violence could occur.
Vous auriez une
Well, then, would you have a specific proposal with regard to what you've just said? Have you thought about some kind of a text that could be used by the committee to make an intelligent recommendation to the government with regard to the bill? If you have anything to suggest, or could you send us something?
Mr. Chair, we can certainly look at some language and recommendations. I think you'll probably receive lots of helpful input through the committee hearings about the way that the language could be used and interpreted. I think for something as significant as this, because like I mentioned, alcohol and intoxication is present in so many contexts of violence, having a plain language summary at the top of the bill, even within the criminal code, that articulates the essence of what's being said, followed by the legal language, which I understand is important, I think that could help to clarify.
Thank you very much. And following question: do you think that the minister had two choices, either create a dangerous intoxication offense or showing the risk of a loss of control and of harm that would be the result of this lack of control? And there are people that had doubts about the efficiency of the law. For example, Professor Parent at the University of Montreal Faculty of Law said that the text didn't include risks that defense lawyer could be used referring to a psychosis or something. Have you thought about that? Do you think it's important to clear up all these inconsistencies before going any further?
There are parallels with other types of behavior that I think need to be considered. So with something like psychosis, generally it's understood that it's a partial break from reality or a partial difference in perception. And I think that the way that we're talking about extreme intoxication may be oversimplified in reality, and that we need to consider the fluidity of the impact of extreme intoxication. I think that's a really important consideration, and that the impression of victims of crime should be considered in that, like has been recommended. But I think it's an oversimplification in assuming that there's a complete disconnect that's permanent throughout the complete duration of an offense.
Merci beaucoup.
Thank you very much. Do you agree with the minister when he appeared before us, who said that this clause, 33.1, would be easy to apply? Do you think we've understood your doubts about the exact wording, where as long as the content is valid?
Mr. Chair, I don't believe that it will be a common defense. I think that there is a high threshold that's established in the law, but we do need to monitor it to ensure that it doesn't become more common. I think part of the, as was raised earlier, the concerns about the bill, there was some misunderstanding about what it meant, and I think that some of that would still be part of this process. So I don't think that it will be a common defense, but I think that the perception of Canadians still has power to influence the way that sexual assault survivors choose to report or not report.
Thank you, Monsieur Perrault. Next, we'll have Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair. I hope the technical difficulties have been resolved. Could I just get a thumbs up if they have or haven't from my end? Okay. So I want to thank both the witnesses for being present today. And I also want to welcome the new Ombudsman for Victims of Crime. And I do say that I sympathize with him being called before a parliamentary committee when he's barely settled into the chair. And I appreciate his intention to consult widely before taking on more specific perceptions. But I want to start by asking you, Mr. Roebuck, do you believe that when Parliament acted quickly, that this did anything at all to stem the perception that a big gap had been opened in the criminal code, which would allow perpetrators to get away with crimes by claiming extreme intoxication?
Thank you for the question. Mr. Chair, I do believe that there was value in quick action on this matter. I think that the misconceptions were continuing to grow, and without a legislative response or a response from the House, I do believe that it would have caused further harm to survivors of sexual assault and partner violence and other forms of victimization. I think that there's still work to do in terms of communicating clearly with the public so that we can uproot some of the misconceptions that were present in that period of time. And there are still concerns to address in monitoring how this bill will impact survivors. I do believe that the immediate action was justified and important for the safety of survivors in Canada.
And I too regret that we didn't have you in place sooner so that you could have been part of our consultation on the study we're doing on victims of crime. But I certainly look forward to having input from you as we go forward in this committee in the future. So I want to turn to Ms. Thomas, and I want to start by asking the same question I asked Dr. Roebuck, and that is, do you believe that Parliament acting quickly did anything to help staunch that fear that some major gap had been opened, which would allow people to claim extreme intoxication as a defense?
Thank you. I think quick action is certainly a good approach. However, the impact on the views of a community of people that have been so affected by violence and sexual violence, I think it's very difficult to have perhaps the understanding of how big that gap is and how much damage occurs, in the public with people who have experienced this kind of violence. Because of the history of sexual violence particularly, but other kinds of violence, never being addressed and survivors not getting supports that are required. I think while quick action is important, I think a lot more needs to be done to stem these concerns.
So in the context I've been using before, it may have been good to have action, but it's not sufficient to stop with C-28, but there's a lot more we need to do in terms of supporting victims of sexual violence. In your opening statement, you talked about the challenges faced by women in general, but also marginalized women, including those who might use substances, face in the court system. Could you talk a little bit more about those challenges and what's being done, if anything, to meet those challenges?
Oh, that's a really big question, and it's a lot to answer. So I'm here representing RIN, but, I have many years of experience doing frontline work with, people who use substances, but also, supporting people through court systems. And I mean, poverty is a number one challenge. And if you're a poor person in Canada, your access to legal supports is minimal. My experience with most people who are in either, particularly the provincial systems, but also the federal systems is, people, if they do not have access to legal supports, often end up pleading out and serving time, whether they're guilty or not, just because that is the only option available to people if you don't have money for a lawyer. And I'm sure I don't need to talk about how the situation in poverty in Canada is increasing with costs of living and so on. But then, there's also all those other challenges that are experienced. People who are Black or Indigenous are disproportionately stopped by police. There's plenty of evidence on that, and I hope that as we continue to collect more race-based data in this country in various places, that we'll start to see facts and figures on that information. So, again, poverty, race, where people are, the address where people are calling for crimes. I'm here in Toronto, and I can certainly say that, when you call 911, depending on what the issue is, if you call for an ambulance, the police will come depending on where you're calling from. If you're coming from a poor area, that's when the police will also automatically arrive. So, and then, on top of that, another challenge is the fact that, we're in a situation right now where we're talking about criminalization of drugs and drug use, which has a direct impact on this kind of law. And when people are criminalized for substance use, then the people who will be disproportionately impacted and more likely to be arrested or charged will be, again, people who are poor, people who are racialized, and people who are otherwise marginalized.
Thank you, Ms. Thomas. Thank you, Mr. Garrison. I will next go to a 5-minute round, beginning with Mr. Caputo.
Thank you, Chair. Ms. Thomas, thank you for your work. My wife does work on behalf of women in a similar capacity, so I'm obviously appreciative of your work. Thank you, Dr. Roebuck, and congratulations on your appointment. I'm going to begin by talking about something. It came to me earlier here today when I was listening, and there's a crucial distinction that I think needs to be made here, and that is the raising of a defense versus the success of a defense. Two very different things. And the raising of a defense is dependent upon the threshold that has to be met, as in when can somebody raise this defense, in what circumstances? Here, it's a question of whether there is extreme intoxication. Now, the Minister of Justice came forward and said, look, this defense will rarely be successful. But that's a lot different than this defense will rarely be permitted to be raised. Very, very different things. Now, when I look at the criminal code, particularly sections 266 to 278 and onward, this is what we see. If a person wants to raise evidence of prior sexual activity, for instance, as part of their defense on a sexual assault or sexual interference or the like type of allegation, or if somebody is pursuing a record that relates to the victim, they have to go through an evidentiary hearing that is separate, okay? Now, in this case, we don't have a separate evidentiary hearing. We just have, this is defense that can be raised. In those two examples that I cited, as I recall, the victim is actually entitled to standing in the courtroom. What that means is that the victim is entitled to a lawyer, and the victim is themselves entitled to make submissions or make an argument to the judge. So on the one hand, we have this robust system that says we're going to have a high threshold, and before we even get to that threshold, we're going to have the judge hear whether this is appropriate. On the other hand, we have extreme intoxication, and that defense can simply be raised and the victim isn't heard. That's what I see in Bill C-28. And as I was thinking and listening, what I was left with is this. Wouldn't it be prudent if we developed legislation that mirrors, say, Section 276 and 278 onward, that said, before you raise this defense, you actually have to have a threshold hearing before the judge. And at that threshold hearing, a victim could actually get their own lawyer. Would that be something that, A, would perhaps diminish the use of very questionable defenses of this kind being raised, not successful, but being raised, and B, would it take into account victim concerns more greatly? I appreciate this is quite a loaded question, so I know that'll probably take up most of our time. So, Ms. Thomas, Dr. Roebuck, I'm happy to hear from both of you on that point.
I could speak very quickly. I think that is certainly a good consideration. However, I would come back again to my points about access to legal aid. So if such a measure was taken, then there would also need to be, financial support for the victim to be able to access a lawyer, because having the right to access a lawyer is not the same as being able to actually access a lawyer. That's my comment on that point. Thank you.
Thank you. And I know in British Columbia, legal aid is provided for such applications.
Thank you for the question, Mr. Chair. I think probably a number of lawyers across the country are nervous with the direction of that question, but I think it's very intriguing, and I think that we can do a better job at exploring the standing of victims in the court process. There's other countries where there's more rights in place around legal representation for victims, and there's pros and cons of different approaches to it. I think that I just want to acknowledge that the raising of the defense can be just as harmful to the victim as sometimes a successful defense. It causes distress to go through the court process. So I think if there's a way to consider it early without it needing to go through a full trial, I think that that's valuable. And I think that it merits more studies. So it's a very interesting question.
Well, I'm certainly not trying to alarm anybody. I'm trying to look at the mechanism by which we get to the most efficient trial that balances the charter rights of the accused, but also recognizes the inherent harm that victims go through in what we would often call secondary victimization, the primary victimization being in the offense, the secondary victimization being going through the trial process. And I think, Dr. Roebuck, you just mentioned, we have to balance these things, and what I'm putting forward is a balance. So I hope that this is a recommendation. I see my time is up, Ms. Thomas. I thank you for that. That's a very vital issue as far as financial assistance for representation, because let's face it, most people who are victimized can't afford a lawyer. So I think that would have to be dependent, and I would urge legal aid in all provinces to make that funding available were such a recommendation to be accepted. Thank you.
Thank you, Mr. Caputo. Next, Ms. Diab for 5 minutes.
Thank you very much, Mr. Chair, and Ms. Thomas, welcome, and to you, Mr. Roebuck, congratulations on your new post. I'm sure there's a lot of work ahead of you. I've listened the last number of sessions, a couple of weeks now, talking about what the government had to do to bring forth, and I'm also listened to a lot of the misinformation that was there prior to the introduction, but quite frankly continued misinformation that is also out there. And, as a woman, that disturbs me a lot. So, Ms. Thomas, thank you for your testimony and just bringing to light again once more that there are support services that are desperately needed, for women who experience sexual violence, intimate partner violence, gender-based violence, all of that, obviously for all victims' rights. I guess what I'd like to ask you, Mr. Roebuck, since you're with us today, can you please share with us what are the support services that are available across Canada for victims? And in particular, perhaps if there's any particularly for sexual assault survivors, for women of intimate violence, and so on.
Thank you for the question. Mr. Chair, across Canada, we have diverse responses to victimization, as each province and territory have different mechanisms for funding and supporting services. What we see in many places would be some sort of generic service for victims of crime that any type of survivor can access. In Ottawa, we have Ottawa Victim Services that would be more generic. And then there's specialized services for survivors of sexual assault, like a rape crisis center or a sexual assault center, or specialized services around domestic violence. It's always challenging for many of these services to be funded, and many pursue grants year after year for pilot funding or cyclical funding, and spend so much time trying to secure the resources to do the work that they could be spending on serving survivors if they had more resources. Our research center, prior to coming into this post, had looked at the well-being of the victim service providers in this time during the pandemic, and certainly the pressures of responding to these complicated cases is taking a toll. So I think we need to do a better job of supporting the providers who are trying to work with the survivors.
So I take it the services differ depending on what province or territory you're in. So I guess a second question to that is, what can you in your role do to sort of have more of an equal footing for any victim across the country, regardless of who they are, what economic status they have, and quite frankly, where they live?
Thank you, Mr. Chair. I love that question. I do have a limited jurisdiction in terms of looking at federal legislation, while the administration of justice and a lot of victim services are in the provincial and territorial jurisdiction. However, we have really wonderful groups like the Federal Provincial Territorial Working Group for Victims of Crime that's bringing together provincial stakeholders with federal stakeholders, sharing information and really starting to consider some of the ways that we can improve services across the country. I think we definitely need a better connection with the transfer from folks in the provincial victim services into federal if there's an offender that's sentenced for 2 years or more.
So, Ms. Thomas, would you have any recommendations to make for us in terms of how best can we help you to get more information out to the people and the women that you are serving?
That's a big question. I think, I'm just echoing this recognition between the this disparities between federal and provincial systems, and the disconnect that occurs. I'm heartened to hear about a provincial federal victims committee or I forget what it's called, but that discusses this. But I think that if if the committee would like to share this information, it needs to go out through those networks that already exist, because there are networks throughout the country. And as others have said, they differ in, depending on if you live in a rural setting or in a city. I mean, I'm in a city, I'm in one of the biggest cities in our country, and I can speak just from here. I know that the services are insufficient. So I can only imagine how that is for, someone living in a rural area. So I think it's crucial that if you want to talk about communication, you are going to want to kind of look at the services and systems that are in place and talk to the people who are doing that work on the front lines now. That's how the information will get back out to victims and survivors and advocates that do this.
Thank you, Ms. Thomas. And my time's up.
Next, for 2.5 minutes, we'll go to Mr. Perrault.
Thank you very much, Chair. Carrying on with the same issue, Ms. Thomas, my big fear with this bill is that all these subjects raised by this bill and the problems of fear and hesitancy on the part of victims to file a complaint. And I'd also like to hear what we think about the need for the government to have answered quickly. But do you have any recommendations to the government to assist them in responding?
I'm not clear on what the question is.
OK. Ce que je disais, Madame.
What I was saying is that the fear that I have, and that you mentioned as well, is that the victims, with the victimization and the questioning of Article 33.1, even if we've tried to react clearly to reassure the public, there is a fear that in spite of all this, and Mr. Roebuck said this as well when you mentioned the importance of having a clear idea so that information can be shared with the public. So I'm afraid that women, victims, might be more afraid than in the past to file a complaint because of this situation, because of this defense of intoxication. And do you have any recommendation for the committee and the government in this regard?
So I think you made a key point there, which is, despite the quick response about the issue, you know, there will still be this concern. And I think that speaks deeply to, you know, the history of how these systems work and why all of the underlying issues of why women, you know, particularly sexual violence, but other kinds of gender-based and intimate partner violence do not speak up, because there are not systems in place to respond to it. So no matter how quickly the government may respond, if those systems and services are not in place to help survivors, then it's very difficult for people not to become more afraid that, you know, this defense is going to fuel a system that already works against victims and survivors of sexual and other violence. So, you know, again, my recommendation is really look at those systems, you know, and how they're unevenly distributed throughout the country. And if you consider the underreporting of those crimes versus how many there actually are, and then how, you know, funding might be distributed to those services based on reported crimes, I think, you know, you might start to get that picture together.
Thank you, Ms. Thomas. Thank you, Mr. Pearl. Last, we have Mr. Garrison for 2.5 minutes.
Thank you, Mr. Chair. And I want to thank both the witnesses for bringing our attention back to the larger challenges that we face in the justice system beyond those we're addressing in C-28. And I particularly want to thank Ms. Thomas for reminding us of the interaction between poverty and systemic racism and access to justice in our system. And I'd just like to briefly give each of the witnesses a chance, to, since its time is drawing to a close here, to add anything that they wanted to say at this time in these hearings. So maybe Ms. Thomas first, and then Dr. Roebuck.
Thank you. I don't think I have anything else to add. Just, you know, again, a reiteration that of the appreciation of having us come and speak and recognizing those intersections that you just mentioned.
And Dr. Roebuck.
Thank you for the question, Mr. Chair. I think it's important to consider the compound effect of a number of legislative pieces that are happening right now on survivors of violent crime. If we have questions about intoxication, the Supreme Court strikes down the mandatory reporting on sex offender registries, and victims see measures like mandatory minimum penalties being dismantled. I think that there's work to do in terms of ensuring that we're considering the rights and protections of victims and looking to mitigate some of this compound effect that's happening at the moment. And I'm very thankful for the work this committee is doing, and I look forward to working with you over the next few years. Thank you.
Thank you, Mr. Chair.
Thank you, Mr. Garrison. That concludes our first panel. I want to thank both witnesses for attending, and we'll now be suspending and joining back in an in-camera. So I want to dismiss the witnesses, and we'll come back in a couple minutes.